Rivers, he's the criminal lawyer. Who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another episode of Criminal Lawyer Reacts. I'm Bruce Rivers, a board-certified criminal defense lawyer. Today we're going to react to a couple of moments in the Young Thug case. Now, one of the things that when you're in court... Hang on. I almost forgot. This episode, like all of our episodes, is brought to you by eSign.com. eSign.com is an effective way to remotely do business. Let's say you're in court, and let's say the judge sanctions you. You have to do all this stuff, and you need to get something signed, by a probation officer or something like that. Well, and you don't want to go in because you got a warrant, so you do eSign.com. So eSign.com, you download the app, you get 3 free signatures a month, and it's an effective way to remotely do business. I do business with it all the time. Why? It cuts down on the time that it takes to seal a deal. So whether you use it for power of attorney, any kind of business agreement, or anything that needs a signature quickly, so eSign.com, it is an effective way to remotely do business quickly. So we're watching the YSL case in Atlanta, okay? This is Fulton County, and they're doing jury selection, and this is going to be an arduous process because they think it might even be a 9-month trial. Who wants to sit on jury duty for 9 months? Nobody does. So, and the problem with that is, you get like, I don't know, $15 a day, and maybe you get lunch, maybe you don't get lunch. And so who can take 9 months off except for retirees and the unemployed? If you're unemployed, then you don't really care. But for the average Joe, it's very difficult to take that time off. Now, when you have a case like this, that's a very high profile, very long, and very voluminous in terms of discovery, it gets tiring. It really does. And the tempers can flare. And, generally speaking, though, it's been my experience that criminal lawyers are different than civil lawyers. Criminal lawyers, you have to try a homicide with each other, and you got to live to fight another day, so you try not to burn a bridge. You can be an effective advocate without being an asshole. Civil lawyers, on the other hand, tend to go like this, but we do that sometimes too, not very often, but so this judge is not taking any shit from anybody in this trial. So the judge here is a guy by the name of Earl Glanville. And I really, really like him because he's not taking crap off of anybody, and he's not dishing it back in a way that's traditional. Show you what I mean.
How are we doing on that paper? I mean, the importance of professionalism. Yours. So
when you're in court, you are subject to the judge's rules, right? So if the judge tells you something, you better listen to the judge because the judge has the power to sanction. And there's a couple of different ways the judge can sanction. The judge can sanction by jail, if there's direct criminal contempt, and that means something that happens in contempt right in front of the judge. The judge can issue a fine, or if you want to stay out of jail, the judge can make you do things. So watch this. This is hilarious.
Due by the 28th of April. I'm just clocking. So we on track? Well, your better half said she's not writing it for you either. Okay, well, I just want to let you know that, okay? All right, so we're good?
That's the judge flexing a little bit, In other words, you got homework, right? You want to stay out of fucking jail? You got best do your homework. Listen to him.
I'm sorry? Because that was...
So he's asking the judge, why can't I just pay a $250 fine? And the judge says, because that wasn't offered to you.
You already asked me, could I pay the $1,000? I told you no.
And one of the things, you can tell he's sideways with the judge. You know what you do when you're sideways with the judge? You make your record and you shut the fuck up. You just shut up. You don't try to challenge the judge anymore because it's going to be a no-win game.
Well, I know you would, but that's not what's on the table. 28th, yes, at noon. or you do 20 days. It's 17.
Or you do 20 in 25 years. I've been sanctioned one time, and the judge ordered me to pay $100 to charity of my choice, and it was just because I was late in federal court. That's how. But in 25 years, that's the only time that's happened. I've never seen a judge threaten to put a lawyer in jail.
Page paper on the importance of professionalism in the legal field and treating one's opponents with civility.
So he must have said something awfully poor to the other side.
Paper is to be published quality in APA format and at least 10 primary and 10 secondary sources.
Boy, I guess you got your homework cut out for you. I mean, 10 primary, 10 secondary sources, AP format, and look at the brow. If I'm not a body language expert, but look at how wrinkled his brow is. He's like, what the hell?
You should be able to send it to the to either the Georgia, any one of our law review or any other place that accepts publications, and it should be acceptable.
In other words, it best not be just a letter.
Say again? Say again, Mr. Jimenez?
It's very difficult to get published, you know. I've never been published.
Okay, all right, okay. But that's another issue that we're not going to deal with today. But anyways, okay, so Mr. Johnson, are we good with that? I mean, it needs to be a scholarly.
And when the judge says you're good with that, just say yes and sit the fuck down.
Basically, okay, that you would, it's error-free and that you would turn in to satisfy a writing requirement.
So you're saying I should, what about just trying to pass the class?
That's not what the order says, sir.
And you should. This is a time where you just sit down and say, "Yes, sir. Yes, Your Honor. I got it. We're good."
Well, I'll put it this way: as long as you write it yourself, and it is completed in the format that's dictated, APA, at least 10 primary and 10 secondary sources, that will satisfy the contempt. I mean, I'm going to read it, and if I don't find it to be of suitable quality, you'll redo it.
So it would be unnerving to get a directive like this from the judge without knowing exactly what the judge wants. You know what? And that's exactly where the judge wants this lawyer, because he wants him to think about the uncivil way he treated his opponent. And we'll figure out what that is in a minute. But I just watch the rest of this, because this is a position you don't want to be in as a lawyer.
But the other thing is, if you don't do it, the other option I have is to jail you for 20 days because it's not satisfactory. So,
how unnerving! Okay, write a paper, and you're not just going to get a bad grade. You're going to jail if it's not good enough.
I suggest that you write it in a satisfactory manner. I'm not, lawyers. We talk and write. That's our trade and stock. So I think you'll be able to do it. I know you'll be able to do it.
He is like sitting on the back of his chair and it's just about to fall over.
You pass the competitive examination, you're a licensed lawyer, you have a 6-digit bar number. I am certain that you can do this assignment. Any other questions, sir? Okay. All right. Mr. Menendez, good morning, sir. You were supposed to buy lunch for your colleagues. Have you done that as of yet? You were supposed to have done that by March the 17th.
So this is another guy that's found in contempt. He had to pay $250 and buy lunch for your colleagues. In other words, the people that you insulted.
Did you go to, did I told you Jason's Deli? Did you satisfy that prong of your contempt?
So he's got the Abraham Lincoln going on there.
I don't believe I was, Your Honor.
You were held in contempt, young man. And if you want to revisit that again, we can certainly open it up. But I satisfied your contempt by you paying $250, which you did, and I have a receipt from that of your choosing, which that was done to.
When I was younger, when I was a younger lawyer, my dander got up like really, my skin was very thin, and it was so stupid. I would judge people, harsh way, and I'd have a knee-jerk reaction, thought I was hot shit. You know why? Because I didn't know what the hell I didn't know. That was one of my issues. As you mature and you progress, you kind of see the outcome of things, right? And you see what works and what doesn't work. You know what doesn't work? Being a complete prick. That never works. Doesn't work with a jury, doesn't work with your colleagues, and it doesn't work with a judge. Might work with your clients sometimes if you think you're trying to play a tough guy, but it generally just doesn't work. So if someone's being a jerk, guess what? You shut the hell up and you let them dig their own hole.
Miles College, I have that receipt here. And the other thing was to purchase lunch for each of your attorney colleagues in this case on Friday, March.
And really what he's doing there is he's trying to get you to think about the other side. He's trying to get you to think about the people in the room. Writing a paper on civility and the practice of law, with 10 primary and 10 secondary sources. Gee, Judge, what's the primary? What's the secondary? I haven't seen that since law school.
17 from Jason's Deli. So prong one's been settled. Prong two was you're supposed to buy your colleagues lunch by that.
And you buy him a sandwich with just a shit ton of the hottest peppers you can find.
Hey.
No, not really.
Okay, so when I just want you to pick a date.
Whatever it is, you're for Mason.
Okay, all right. Well, look, I don't have any issue with it. I'm not the person that's going to partake, so it's okay with me. Let me just check right quick.
And when you're in the hot seat like this, let me tell you one time I got sanctioned, and it was in federal court. I show up to court, and I didn't even have it on my calendar for whatever reason. And all of a sudden I get a call from the prosecutor. Rivers, we've got a plea across the street. I'm like, oh shit, I'll be right there. So when I get there, the courtroom door is locked. My client's in there bawling her eyes out. Her husband's there and her cousin's there. So it was a drug case. And I'm sitting there waiting, and then I knock on the chamber's door. They come out and they said, well, the judge doesn't want you in the courtroom right now. So I go to the court. I just wait and I wait. Judge goes off the bench. Then they open the door. When they open the door, I come in. My client, I'm sorry, I was only like 10 minutes late, and the judge had locked the door. So he comes back on the bench. He looks at counsel. He says, good afternoon, counsel. And I say, good afternoon, Your Honor. He looks at me and says, good evening. Counsel, approach the podium. Fuck, I'm going to get it. This was the chief judge at the time. And so I go to the podium, and he says, counsel, where have you been? This big booming voice. And I'm like, Your Honor, I apologize. I was at a sentencing across the street with Judge Daly. Judge Daly has a telephone in her chambers, I presume. Isn't that correct? Yes, Judge. Yes, I'm very sorry. I'm contrite. And I've seen you on your cell phone. You do have a cell phone, don't you? Yes, Your Honor. Yes, Your Honor. And he says, and you didn't think to call. I know, Your Honor, I completely apologize. You will donate $100 to the charity of your choice. Now sit down. So I sit down. Then we get up to do the plea. And one of the things he asks the defendant is about the lawyer's services. Other than today, have you been happy with your lawyer's services? And you feel like about that small. So when you're sitting in that hot seat, it's just like you want to chew your arm off to get away. And you're sitting there taking this shit from this judge. Meanwhile, look at you, the client's looking at him. You can lose confidence in the client.
I think that's the heat that we're going to have.
May 19th would be fine. Most of your colleagues would be here anyway, so does that work for you, sir?
That works for me, Judge, and also I never saw the contempt order. I misinterpreted the whole thing.
I have it, and I haven't, we have not entered it because I want you to satisfy it first. Because then I don't have to include the incarcerated portion of that, okay?
Judge, I did misinterpret it, and I want to appeal that. I apologize.
So why would you even bother? He says, I want the order in writing so I can appeal it. You know, because the judge may be overstepping his bounds on what he can do on contempt. And, you got to be in front of that judge again. Just buy your fucking colleague's lunch and see you later. I mean, it's not that big a deal. He's challenging the judge right now. And when you challenge the judge on something like that, honestly, what are you doing? I mean, because all you got to do is buy some sandwiches.
Hold on one second, sir. I just turned mine off. I'm sorry.
And these are very hard-fought cases. There's a lot of tension going on. And you can't quite get the tension that goes on in a courtroom when you watch it on TV. But trust me, there's a lot of tension in that room.
Mr. Menendez, this was in satisfaction of me not sentencing you to jail for 20 days. So if that's the case, well, then I will revisit the basis for your contempt. But I thought that, and in fact, I'll have Ms. Weaver go ahead and pull that order, pull the part of the record. But I did, in fact, I did not hold you in, I did not go ahead and sentence you to the 20 days. I said that this would satisfy, once you apologized, I said you can pay, because remember, you were going to do I was going to have you do a report as well, or a written product. I was also going to, but instead of doing.
So what the judge is basically saying is, I wasn't going to even enter this order on the condition you buy your colleague's lunch and pay $250. You paid the $250, and now he wants to. It's like when you want to die on this hill.
That we settled on the $250, and we settled on your buying lunch for your colleagues on the 17th of March. So that was my understanding.
My understanding was that I apologized and that I was doing that to sort of show how serious I was.
It doesn't matter what your understanding is because it's the judge's order. So just buy some sandwiches and shut up.
I'll still buy the lunch and then
And that will satisfy. Then that will satisfy this court's concern. Okay.
I just want to make sure I don't miss my time for this, but I'll appeal it and then I'll still buy it.
Your Honor. Give me 1 second. You want to chat with him? Okay.
That's a younger lawyer kind of thing. Shut the hell up and sit down. All right, so that is the judge in the YSL case talking to the lawyers. The judge also has the power over the jury, So if there's misconduct from the jury, let's see what he does there.
Good morning.
Madam, just to recap, you were summoned as a juror on the 17th of March of this year to begin the jury selection process. Is that correct?
Yes, sir.
All right. And during that particular process, do you recall, and let me back up just a second, because of conduct that occurred or alleged conduct that occurred on the 17th of March.
You notice the judge doesn't look like the judge is sitting in his chair. Judge is likely on Zoom.
You were served with a order
no,
to show cause. That was filed on the 20th of March of this year to appear on this date, the 3rd of April at 10 o'clock in courtroom 1C. You received a copy of that notice, didn't you?
Yes, sir.
All right. And that notice also gave you sufficient notice that, as to why you should not be held in willful contempt for.
So, like I said, there's two types of contempt. There's civil contempt and criminal contempt. Civil contempt is when you don't obey a court order outside the presence of the judge and you have the keys to the jail. In other words, satisfying the requirements of the order satisfies the condition of contempt. But when it comes to criminal contempt, if something happens in front of the judge can sentence you to jail right then and there.
The court's admonitions against improper jury behavior, specifically live streaming the jury selection process on Friday, March the 17th.
Live streaming the jury process. You have to kind of have some balls to do that in a situation like this. What the hell? Who could be thinking that was a good idea?
Of 2023. Do you recall that? I'm going to include that as a copy of the next court exhibit in order. That's your notice that we gave you. So you are at this point in time. Why shouldn't I hold you in willful contempt?
So keep in mind that the jury is instructed from the outset as to what the conduct should be and shouldn't be. You're not to tweet about this. You're not to do any social media about this. You're not to discuss this case, blah, blah, blah. They get these instructions, and those aren't just suggestions. Those are court orders. And if failure to follow a court order...
Okay, so I'm going to explain everything that happened that day on the 17th of March.
Okay, but before then, do you recall this court giving you the ad nauseum admonitions about acceptable behavior?
About having phones out?
Yes.
At the moment when we came in.
Didn't I tell you to turn your phone off?
It was, I'm going to be truthfully and very honest. When it was a lot going on, we had just come from different
Answer
floors.
my question first, and then you can explain it. Do you recall us telling you to turn...
That's a notice requirement. So he wants her to acknowledge that she got the notice.
Your cell phones?
Yes, sir.
Okay, you also recall me going through a litany of different things that would cause us to potentially put the case in jeopardy. Do you remember me saying that to you?
I mean...
Because here's the thing. If somebody's live streaming this, that's a violation of the order, number one. And number two, it can prejudice other potential jurors and cause a mistrial. And then you got to start all over.
Couldn't hear. It was so much people. It was so many people talking and so many people doing different things. So people were talking when I was giving that admonition to you? Meaning that you didn't hear it? You didn't hear any of the 10 minutes that I went through on the record about the things you couldn't do? Specifically, you couldn't research on Google. You couldn't go ahead and otherwise contact your friends on social media.
You hear the way the judge is speaking right now? That's exactly what his admonitions that he's talking about sound like.
Well, I remember the part when you're saying we had to, but I didn't hear the turn off the phone.
Remember me talking about no...
Good idea, because likes and follows and everything, if I just live tweeted it. I mean, what are you thinking?
Social media.
Yes.
Do you remember me also pointing to the placards that are on the wall about social media and the things you cannot do?
And I didn't see that until after the fact.
You don't recall me pointing that out to you?
No, sir.
Then you weren't listening and you weren't doing your job.
But you were, in fact, told to, one, put away your phones, and two, that you could not otherwise, you do remember, you couldn't otherwise post, pin, tweet, or otherwise.
And I didn't.
Send anything to social media.
Correct, I didn't.
But you did live stream our proceedings, didn't you?
It wasn't live streamed at all.
So what exactly did you do then?
Okay, so when you was giving the speech, everybody was talking. I did.
And nobody else was talking. When the judge is talking, if that didn't happen.
Take a video, and then the young lady next to me, she was like, "Man, we're not supposed to be recording." Soon as they said that, I deleted everything right then and there. Maybe an hour went by. That's when the officer came up to me and said, somebody had told us that you may be recording. So I showed.
That's the other thing. They tell, the fellow jurors, if you see something, say something. In other words, if your fellow jurors are doing something that's inappropriate, you got to bring it to the bailiff's attention.
The phone, they went through my recent deleted photos and seen the video that I made, but it was already deleted because the young lady next to me had told me that you did say we wasn't supposed to be doing any of that. And this is my first time. That was my first time ever being in court in my whole entire life. So I wasn't really sure of anything we couldn't and could not do. So I do apologize for that.
You are here in one of the highest profile cases ever to hit the Georgia courtroom. And the judge is telling you what you can and cannot do, and you don't have a clue that you're not supposed to record the proceedings on your fucking cell phone?
I went through a very long and arduous process.
I had a jury trial once, and this is in federal court as well. And this woman gets up and you know, they draw the federal juries from a lot further around. It's not just the county. This woman was just panicking because she has kids and she lived in southern Minnesota, and she started crying, and the judge says, well, do you have an issue? And she says, I don't know how I'm going to make this all work. And, you know, and she's just crying, and the judge let her out of jury duty because it was going to be a real hardship for her. Well, this woman was chewing gum in court, and she's like, and he asked everybody, does anybody else have an issue with this? Or like, you know, this other woman? And she raises her hand. So all I got to do is shed a few tears and I can get out of here? And she was kicked off the jury. She got what she wanted. But this is a solemn duty as a jury. It's one of the only times that your government really asks something of you, where you participate in making a decision about somebody's life. It's super serious. And in this case, you know, we're looking at murder charges.
Of telling people what they could not do.
Correct.
And you violated that. And you put this trial in jeopardy because of doing that, because of your actions of that. And I told you that the reason that we put such a big emphasis on this is because people actually do this kind of stuff. They go ahead and they take pictures. They go ahead and visit the scene. They go ahead and talk to their friends on social media. They talk about and try and learn things.
And you have rules. You have rules set up for a very specific purpose. Because, and it may not make sense that a certain piece of evidence doesn't come into court, but it has to come in through the rules of evidence.
The case that they're not supposed to, aren't presented in the four walls of this courtroom.
Yeah, it wasn't posted on social media or any type of.
Well, I know that, but I told you don't even get on your phones and to not record anything.
And I told you that until the middle of the court.
Well, the lady sitting behind you saw you going ahead and videotaping these particular proceedings, and that was in violation of this court's order. So I'm gonna contempt is punishable by a fine of $1,000 and or 20 days in jail. Madam, I think that given the amount of time and energy and effort and care we spent in making that particular pronouncement, and I tell it multiple times for multiple reasons, and you decide you're gonna just do what you wanted to do.
It's not
pull out your phone
and, what I wanted to do.
Well, you pulled out your phone and videotaped our proceedings, and that was in
I'm sorry is the right answer here. I mean, there's no defense to what she did.
Violation of this court's order. So I'm going to sentence you to 3 days of in jail, and that will otherwise satisfy your contempt. So
it's not going to be the payment? I thought you said.
No, I'm not going to fine you $1,000 because this court, I've given this same admonition a number of times, and there are varying reasons that we punish people in society. Okay, I'm just going to tell you the reasons are: one, just general is retribution, eye for an eye. The second reason that we punish people is for general deterrence. We don't want other people doing this kind of same thing.
So think about that. You're a fellow juror, and you see somebody going to jail because they misbehaved on the jury. What do you think? That has kind of a chilling effect on you, don't you think? It has, it's like, better, straighten up and fly right.
reason is specific deterrence. That means we don't want you doing this again. And then it's rehabilitation and reentry. So, ma'am, in this particular situation, unfortunately, I have told several people and made several iterations of this particular notice. And
here's the thing. I think the temptation in a highly publicized case where you've got a famous rapper that's on trial for a RICO case and it's nationally known, the temptation is there to do some shenanigans.
You videotaped our proceedings. It was just a brazen violation of these particular proceedings. I told you not to. If you just left your purse in your pocket, you would have not even put yourself in this particular predicament.
Right, but it was so much going on. I suffered.
That doesn't excuse your behavior and doesn't give you.
I didn't hear every.
Madam, that does not excuse your behavior and it doesn't provide it's an excuse for behavior, because there is no reason you couldn't have taken your phone and put it in your purse when we told you to do that, right?
Correct.
Instead, you took your purse out. You had to go through several manipulations to turn on the video feature for you to go ahead and videotape these proceedings. Is that right? It just didn't come on by itself, right?
Yes, sir.
So that's willful. That's you like saying to me, Judge, I don't care what you said about this kind of behavior. I'm gonna do what I want to do. So for that reason, that's why I'm gonna hold you in contempt for 3 days, and that will otherwise satisfy your contempt.
Your Honor, ready to take her into custody?
Yes, ma'am.
So then take her into custody right then and there. You know, you wake up in the morning, you go to court, and then you don't go home. And 3 days is pretty light on something like that. But, you know, it is what it is. So this is our reaction to some of the sanctions Judge Earl Glanville has laid down, both on lawyers and a juror. So this is really going to be a slog for this prosecution. And it'd be something if it actually gets all the way through. They think this whole thing will take about 8 or 9 months. So we'll see you next time here on Criminal Lawyer Reacts. Make sure you subscribe, follow us on Instagram, follow us on Twitter, sign up for Patreon. Now let me give you a little notice on what we're going to do with Patreon. Starting probably in about a week, we're going to have Saturday sessions on Patreon, where if you're a Patreon member, number one, you get a free hat like this. And then number two, I'm going to do a live session where you can ask me questions about cases. If you have something else, you know, it won't be privileged because it'll be a whole bunch of people in a room. But we'll do a live session on Patreon. And we'll see how that goes. I think it'd be kind of fun. Way for us to interact. And we'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, police is at my call.